Good morning and welcome to Jackson Kelly's webinar on Flagrant and POV by Arthur Wolfson of our Pittsburgh office. From some administrative matters before we get started today, we want to make sure that we limit the presentation to no more than 60 minutes. So we will ask that if you have any questions, please type them into the chat box on the bottom hand right of your screen, and Arthur will address any questions that you raise at an appropriate break in the conversation. He'll also answer any questions at the end of the webinar. If you haven't already, if you could please put your phone on mute. And finally, if you have any problems during the webinar, please feel free to email marketing@jacksonkelly.com and someone will address you. Finally, we will be sending out a web link for this webinar along with the slides tomorrow, along with any certification certificates. So if you need anything, please reach out to us that's not covered. And with that, we will turn it over to Arthur. Thank you.
Good morning or afternoon, depending on where you are located, and thank you for joining us. We're going to talk today about two topics, the flagrant designation and the pattern of violations, which for those of you who deal with mine safety and compliance, mine safety and health compliance, these are very familiar topics to you. I'm sure you've heard presentations before. What I'm going to try to focus this on, as the title indicates, is where exactly are we with this? Because these are not new concepts. They've now been around for a number of years. We've been hearing about them for a number of years, but we're still pretty much mired in uncertainty as to exactly what an operator can expect with respect to either flagrant or POV. And that's unfortunate because they're very strict sanctions, as we all know, and the regulated community would benefit from some more certainty. There's ongoing litigation in both areas. The target has moved during the course of both areas. We've seen instances of MSHA, frankly, trying to expand the meaning of some of the key terms in both areas. But I must say that there's been significant pushback from industry groups in both areas, and that, frankly, has curtailed some of those efforts by MSHA. Not to the degree that we can declare any sort of victory, but it certainly has stemmed some, not all, but some of the tide that we've seen with these two very, very serious sanctions. So with that said, we will get started. And let's talk a little bit generally as to why these sanctions are so severe. Of course, as we know, the flagrant provision applies to single violations that can be deemed flagrant and can carry penalties up to $242,000 for a single penalty. That's, of course, up from the maximum of $70,000 for something that's not flagrant. So there's a significant monetary amount. There's also the stigma of having a flagrant, and whether that carries over into other areas of civil liability or not, which will vary state by state. Pattern of violations, of course, is a more broad sanction, results in closure orders for successive S&S citations if a mine is placed on the pattern. MSHA has trumpeted these two sanctions in the post-SAGO world, the post-2006 world. The flagrant provision was added as part of the Miner Act in 2006, and here you see a statement of one of the senators who sponsored the Miner Act. So this was a key provision in the Miner Act. Pattern of violations has been in the law since 1977, but really wasn't used for most of that time. Current Assistant Secretary Joe Main has indicated that in his regime, it's been a game changer. We'll talk about the changes that have been made in this time. So these are two sanctions that MSHA has really trumpeted since 2006, and we're left wondering, why do we have this degree of uncertainty with respect to both? Let's start with flagrant. And as Mary indicated, I will take questions. We're going to sort of split this program up into two parts, flagrant and pattern of violations. So I'll stop at the end of the flagrant section, and we'll take questions, any questions you have there. And then again, at the end of the pattern of violations section, we'll take any questions there. And if you have a flagrant question and you forgot to ask it in the midpoint, you can, of course, still ask it at the end. That's not a problem. Statutory provision for a flagrant, as I've posted here. Now, recognize two important points. There's both a negligence portion of this, which is a reckless or repeated failure to make reasonable efforts to eliminate a known violation. So keep that in mind. That pertains to a degree of negligence. And there's also, which is oftentimes less talked about, a very important gravity portion of the flagrant provision. Refer to the middle portion of the provision, refers to a violation of a mandatory health or safety standard that substantially and proximately caused or reasonably could have been expected to cause death or serious bodily injury. So we have both the negligence portion and the gravity portion, and we're going to see since 2006 how that has played out in case law. Most people recognize that, most people who follow this stuff recognize pretty easily that there's two general types of flagrant violations. There's the reckless, again, recall the reckless failure to make reasonable efforts, and there's also the repeated flagrant. This isn't new for those of us who follow this type of things. Reckless and repeated flagrant are the two types. And we've seen cases develop along both of these lines. Now, when I talk about the uncertainty that has plagued the flagrant provision, frankly, in the reckless area, there's less uncertainty. And that makes sense. Your reckless flagrants are really going to be on a case-by-case basis. You're going to have a more difficult time trying to draw parallels between them because you're talking about reckless conduct for single instances. Two cases that involve reckless flagrants. The first is Stillhouse Mining, which is cited quite frequently because the judge in the case, Judge Paez, really parsed the language of the flagrant provision, and his analysis has been cited in most of the subsequent flagrant decisions. But what I want you to take away from this case is, as a reckless flagrant, Stillhouse Mining involved 4 104Ds where all 4 flagrants were upheld in an instance where the mine knowingly shut off the fan with workers still underground. Obviously, it's a very fact-specific case, a fact-specific situation, and Judge Paez upheld the flagrants on the facts of that case, a very unique set of facts. Rocks Coal, similar thing. This was a matter where a chief electrician had knowingly made it such that the on switch of an electrical piece of equipment was taped in the on position, and then had workers go and work on it. Obviously, they weren't able to de-energize it at that point. Again, a very serious, a very egregious situation, as the judge found. But the takeaway for our purposes here is fact-specific. So when we're talking about the uncertainties of flagrant, when it comes to reckless flagrant, the fact that the analyses are really fact-specific stands to reason, because we're really looking at reckless conduct, whether it rises to that level, and that's going to be a fact-specific analysis. However, for the repeat, we have a situation where MSHA is trying to paint with a broader brush, not look for such fact-specific cases, but look for reasons, rules and criteria that they can readily designate certain violations as repeat. This is where most of the fight in case law has ensued, because again, we're not talking about fact-specific analyses, we're talking about, frankly, numbers. What gives rise to a repeat flagrant? Remember the pills. Procedural instruction letters. MSHA came out with 2 procedural instruction letters that were not put forth through notice and comment rulemaking, in which they attempted to set forth a broad set of criteria that would support a repeated flagrant. Again, keeping in mind the definition of flagrant from our previous slide here, which would be a repeated failure to make reasonable efforts to eliminate a known violation. 2 cases came up addressing this pill, and this was the criteria that was set forth. MSHA issued one in 2008, and then a follow-up one which expired in 2010 and did not reissue it. 2 cases addressed the validity of these criteria, which were Conshore Mining and Wolf Run Mining, and both found that this was a substantive rule that should have been promulgated through notice and comment rulemaking. Conshore Mining went up to the commission, but then MSHA withdrew the flagrant designation. The case settled. So that case really never went anywhere, although it's an interesting decision to read. Wolf Run, however, did make it up to the commission. And here was the interesting part about Wolf Run. Wolf Run involved a garden variety 75-400. For those of you in underground coal, recognize that's your accumulations of combustible material. MSHA designated it as a flagrant. Initially, when the case was proceeding before the judge, MSHA said it was flagrant based on the procedural instruction letter, the pill, based on 2 prior 104Ds for 75-400. MSHA then offered different rationales for why that was appropriate. Before the administrative law judge, it said there was a substantial similarity. Well, initially they said it was based on the pill. Then after the administrative law judge issued his order, as I said, indicating that the pill was invalid, they changed their theory and said it was based on substantial similarity between the violation at issue and an undefined set of history. And then when the case went up before the commission on interlocutory review, the secretary changed their position and said, no, forget the substantial similarity. We're going to disclaim any reliance on that concept. It is basically because this mine had a history of similar violations. Those of you in underground coal know this is the most frequently cited standard. So essentially what MSHA is trying to do here is to walk in with a list of the mine's history of that standard and say that would make it a repeated flagrant. The administrative law judge rejected that argument. He said, if we look at the definition of flagrant, the provision, the statutory provision, we do not look to past violations. We look only to repeated failures to eliminate the citation at issue. So, for example, if we have a 75-400 in underground coal, did management know about it for a extended period of time and had been warned and had repeatedly failed to correct the condition? That's what the judge said we should be looking at. We shouldn't be looking at past violations, which frankly have nothing to do with the current violation. And incidentally, that's what the judge in Conshore Mining, a different judge, had also found. As I said, Conshore didn't go up to the commission, so we never got a ruling on it. But Wolf Run and Conshore tracked each other in terms of rationale. And this is where flagrant was heading until it got to the commission. The commission said, no, you can base a repeated flagrant on a mine's violation history. That it's not just whether the mine repeatedly failed to correct the condition that was cited, but whether they've had past instances of that. But what did the commission not do? The commission did not tell us the relationship that was necessary between those past violations and the one that was cited. Wolf Run, frankly, did not help the regulated community, because what the commission essentially did was reject what the administrative law judge did and said, yes, you can consider past history, but they didn't tell us how. They didn't say whether MSHA's approach of simply looking to past history was sufficient or not, and if not, they didn't say what additional points MSHA needed to establish to have a repeated flagrant. So this decision, frankly, is the cause of a great deal of the uncertainty that we're currently experiencing in the repeated flagrant area. But we've had subsequent decisions, at least at the administrative law judge level, since Wolf Run. So where does this leave us? As I said, it appears that the current state of the law is that there are really two types of repeated flagrants. There's the repeated flagrant, where the mine repeatedly failed to correct the cited condition, and then there's, at least theoretically, the repeated flagrant, where a mine has a history of failing to correct the same type of condition over and over again, which can be based on past violations. In Judge McCarthy's American Coal decision, he refers to this as the broad versus narrow interpretation. The broad interpretation would be based on your history. The narrow interpretation is based on repeated failures to correct the current condition, the condition that's been cited. However, remember I said that at the outset, MSHA has tried to walk into court with your violation history and said, that's good enough to establish a repeated flagrant. That hasn't gained any traction. Two cases, one, Judge McCarthy's American Coal decision, and also an earlier case, Bowie Resources, MSHA attempted to establish a repeated flagrant based on just that. Attempted to walk into court with the mine's history based on the computer printout of violation history and say, because they have X number of past violations of this standard, that makes the next one a flagrant. Not so has said two judges, both Judge McCarthy and Judge Manning. So at least until we get a commission decision to the contrary, it appears that MSHA must base a repeated flagrant on more than simply the violation history. So where does that leave us? How many? If we're going to look at history, how many? In past arguments, MSHA has actually made the argument that it can be as few as one. I don't think that's going to gain any traction with judges, but they have made that argument. What that tells me, I don't think that's a serious argument. I don't take that to be a serious argument, that you could have one past violation and the next one shows a repeated flagrant. But what it tells me is that MSHA has not nailed it down, that they haven't pinned down how many, if we're going to rely on history, how many of the past violations would be needed to establish a repeated flagrant. Similarity, again, remember in Wolf Run, the commission said that we may need to consider similarity, but they didn't give us any indication as to how. That's another point of uncertainty. If we're looking at past violations of the same standard, do they actually have to be of the same standard? Same area of the mine, same type of area of the mine. And then what about the level of gravity? Keep in mind what I said when we first started talking about flagrant. There's a negligence portion and a gravity portion. The gravity portion, again, is a violation of a mandatory health or safety standard that substantially and proximately caused or reasonably could have been expected to cause death or serious bodily injury. If we're looking at past violations, do those past violations have to meet that definition? Substantially and proximately caused or reasonably could have been expected to cause death or serious bodily injury. Or is it only the cited condition? That is another level of uncertainty for repeat flagrant. I'll come back to screening criteria in a second, but let's look at the bottom point and then we'll come back to the other two. Sticking with the gravity, we're all familiar with S&S. The gravity language in flagrant, a violation of a mandatory health or safety standard that substantially and proximately caused or reasonably could have been expected to cause death or serious bodily injury, that's not S&S. There's case law out there that establishes the point that proximate cause is not S&S. So if we're going to look to past violations, and we're not sure if the gravity has to be what it says in the statutory provision, it would appear, if it does, that S&S cannot stand as a proxy. Does MSHA then have to go back and reestablish those gravity points for the past violations? Again, more uncertainty. The other issues that I raised, the role of the screening criteria, and this same concept will come up in pattern of violations. MSHA has argued that it identifies potential violations for flagrant based on a set of screening criteria. They do not release those screening criteria, and frankly, they say that once they've alleged the flagrant provision, that the screening criteria are then irrelevant. That all they have to prove is that it meets the definition of the statutory terms. That has not readily been accepted by operators who have challenged flagrant violations. So the role of the screening criteria going forward, is that something we can litigate? Is that something we can take a look at and say, hey, wait, if we look at these screening criteria, should we even have been considered? What role does that play? And then looking very briefly at negligence, we talked about the reckless failure, but for the repeated failure, MSHA has argued that reckless conduct is not required. That reckless conduct is only required for a reckless failure, but not necessarily a repeated failure. That has not been accepted to date by any court. But with the cases that are still currently pending, it is another issue that we may see. So before we leave flagrant, to sort of summarize all the uncertainties that I've covered, as I see it, as the development of flagrant since 2006 has taken place, we've talked in terms of two types of flagrant, reckless and repeated, but really there's three. There's the reckless flagrant, like Stillhouse and Rocks Coal. There's the repeated flagrant that's based on repeated failure to correct the condition that was cited, what Judge McCarthy has referred to as the narrow interpretation. And then there's the repeated failure based on your past history. Not necessarily the repeated failure to correct the current citation, but other past instances of failures to correct conditions that have been cited. As I said, what Judge McCarthy calls the broad interpretation. As I see it, the largest degree of uncertainty really lies with the last one. It's the broad interpretation, the role of history, the role of past citations. And that's the most problematic because that's the one that frankly is if MSHA were to establish criteria, would make it easiest for them to establish a repeated flagrant. It's also the one that MSHA and the courts have struggled with the most. What should those criteria be? Clearly, merely relying on past history is not sufficient, but what is sufficient? And that's really the next question, the question that has to be answered for flagrant. So let's talk a little bit about practical considerations before we leave the flagrant section, and then I'll take some questions on flagrant. So if you have any questions on flagrant, after this slide, we'll address those before we move on to pattern of violations. First thing is, pay attention to the role of foremen and managers, particularly for your reckless flagrants. Obviously, this comment is not intended to be any suggestion of micromanaging your foreman. You obviously have to trust your foreman and your managers to do their jobs. But keep something in mind. I've attended a couple of meetings with MSHA that have been given as a result of the rise in metal non-metal fatalities that we've seen over the last year. Those of you in the metal non-metal sector have heard about this. And in both meetings, I've heard MSHA officials make the point that there's been a rise in fatalities of managers in the metal non-metal sector. And MSHA's takeaway from that is we need to be paying more attention to what managers are doing, because if they are the victims of fatal accidents, it could be because the managers are engaged in bad habits. And that causes MSHA and, frankly, also industry angst, because if the managers are engaged in bad habits, what are they passing on to the hourly workforce? I raise this point for this reason in terms of flagrant. Very succinctly, MSHA's watching your managers. They're watching your foremen closely. They've made no bones about that. Well, obviously we want to cut down on accidents. We want to cut down on fatal accidents for all people, managers and hourly workers. But from the point of view of the flagrant provision, if managers and foremen are under the microscope for MSHA, it stands to reason that their conduct will more readily be evaluated for reckless flagrant violations. Keep in mind Rox Cole. The finding of the reckless flagrant all turned on the conduct of the chief electrician. So, pay attention to the role of foremen and managers, and keep in mind that they are under the microscope in the current climate. And I mentioned metal non-metal. For those of you in the coal sector, there's absolutely no reason to think that's not the case for you as well. Redouble your efforts to gather information on citations. Those of you who maintain a very active program to evaluate citations as they're issued and do a very good job of this. We've seen a lot of improvement over the years amongst operators in gathering information. It becomes all the more important when the stakes are higher. Stands to reason. If a violation can go up to $242,000, stands to reason why we need to do everything we can to be gathering the information we need to evaluate citations along the way. Maintenance of documentation. If we're looking at past violations, and presumably some of those would have been contested, if we've maintained information for contests of past violations and we have the inclination they could be used to support a repeat flagrant in the future, becomes all the more important to have a program in place at the mine to maintain documents that may be used in litigation. Every mine in the country can do better at this. There is nobody that can't improve in this function. You know, and I've seen over time serious violations written, and the company says, well, we need to maintain those documents. They put them somewhere they think that will keep them safe, and then they disappear. We need to make sure we have systems in place to maintain documentation so that when we need it, because we may not just need it for the citation at issue, we may need it if that citation is used to support a repeat flagrant in the future. And then what is our response to repeated violations? Again, if MSHA is going to continue to rely on past history, then frankly, we as industry need to be able to say, look, when we got X number of housekeeping violations at the metal non-metal site, or we got X number of roof control violations in an underground coal mine, we took these steps. So merely relying on past history, although judges have rejected mere reliance on the history sheets, if we're able to show what we've done in the past, or to correct the violations that were issued in the past, to redouble our efforts at compliance, that should go a long way to challenging any flagrant designation. So these are just some practical considerations. Certainly not a comprehensive list, but just some things to think about. At this point, if there are any questions on flagrant, go ahead and type it into the chat box. I'll give a minute, and if we don't get any, then we'll just move on to POV. Okay. Well, let's talk about pattern of violations, another very serious topic. Mines want to stay as far away from pattern of violation as possible, understandably so. As I mentioned at the outset, Joe Main has called this a game changer in mine safety culture. In some ways, he's right. You know, it's something that's on everybody's radar. So in that sense, it is a game changer. In other ways, it's kind of hard to know how the games change when we don't know what game we're playing, because as we're going to see, there's, again, a lot of uncertainty in the pattern of violations. As I said at the outset, this has been in the law since 1977. It just wasn't used, or it was used very, very, very sparingly in over 30 years of the Mine Act's existence. But this is the statutory provision, which you can read. The key points, as most of us are familiar with, after a POV notice, and we'll talk about a POV notice in a second, is issued to an operator, subsequent SNS violations result in a withdrawal order. That's the meat of it. That's what causes all of us serious angst, because we can all imagine what the result of that would be. You have to go a complete inspection with no SNS violations to be taken off the POV. And then this is a key point in the pattern of violations provision, and this is where we're going to see the root of a lot of the uncertainty. The Secretary shall make rules to establish criteria and publish those rules and publish that criteria. Well, what might that criteria be? A couple more key points. An online monitoring tool is established. We'll talk about this at the very end when we get to practical considerations. Frankly, this is one of the better, this is one of the positives of the recent rule that MSHA published on POV and the recent approaches. This does allow you to monitor where you are in POV in real time. This is one of the points of sticking points between industry and MSHA, is whether it's based on issued citations or orders or only those that have become final. We'll talk about that some more. All mines are reviewed at least once per year, 12-month compliance history period, and there is a screening criteria included on the website. Before a mine is placed on POV, mitigating circumstances are to be considered as part of MSHA's determination of whether a POV notice should be issued. So this is a summary following the statutory provision of the key points of MSHA's rule, which was published recently. I'm not going to spend a lot of time on the screening criteria because those of you who deal with this, I'm sure, are quite familiar. This is on MSHA's website. There are 2 sets of criteria. This is the first. I'll let you take a look at that. Mines meeting each of these criteria may be considered for POV. Again, this doesn't put you on POV, this just gets you past the screening criteria. And this is the second set. So you either meet all of A or you meet all of B. And this is what's the basis of the monitoring tool on the website, and it was probably is most familiar to everyone. One of the new provisions in MSHA's current rule is the corrective action program. We'll talk a little bit about that. If a mine is monitoring itself using the online screening criteria and has a concern that it's getting close, it can opt to develop a corrective action program. This is to be prepared by the operator and presented to MSHA for approval. If MSHA approves it, and if it is implemented, it may be considered as a mitigating factor for a mine that has met the screening criteria to avoid actually going on the pattern of violation. This is obviously a very, very serious option to consider, because by developing it and proposing it to MSHA for approval, a mine is essentially placing more burdens and responsibilities on itself beyond what's required in 30 CFR. The second point being that if it is implemented, it may or may not end up being considered a mitigating factor by MSHA. And this is something that is, frankly, at the discretion of MSHA. In the past few years, I've had occasion to see mines that have implemented corrective action programs, and they've been successful in both, frankly, reducing their number of S&S citations, and I've also been considered by MSHA as a mitigating factor. I've also had occasion to see an instance where it was not considered by MSHA to be a mitigating factor. The mine placed itself under this, and MSHA did not consider it to be a mitigating factor. So it's something that must be considered very, very seriously, and thoughtfully before it is entered into. Talk real briefly a little bit more about the corrective action program. This is what MSHA had said in its rule that the corrective action program must contain. I'm not going to read that to you, but basically what MSHA is looking for is for the mine to say how they're going to reduce their S&S violations and what benchmarks are going to be established to show whether or not that it's working. So MSHA wants to see the plan, see how you're going to propose that the plan will work, and then they want to see results that it is working. Again, this is what makes it tricky, is that it must be put in place prior to POV identification and have shown positive results in order for it to be a mitigating factor. So it's something that must be considered well in advance of the POV. Here are some items that may be included in a corrective action program. Examinations, were there any management changes? Are we going to engage in audits of safety practices and examinations? Additional training and any other administrative or engineering controls. So that is a feature of the current rule. But let's talk about where this is all going. There are essentially two, and this slide sort of overgeneralizes these two cases, but there are essentially two lines of litigation related to pattern of violation. The first is what I refer to as the Sixth Circuit litigation, and that's somewhat of a misnomer at this point. But those of us that follow the history of this know why I call it that. There was a series, several of the industry groups led by NMA, as well as others, as well as Murray Energy, filed suit against MSHA in the Sixth Circuit Court of Appeals challenging the validity of the rule. That litigation has taken a strange twist in that MSHA was able to show that that was not the proper place to begin the litigation, that because the pattern of violations rule is not a mandatory standard, that the circuit court does not have initial jurisdiction, that it must start in a district court. Had they been challenging a mandatory standard, the circuit court would have been the correct place. That was dismissed without prejudice and was refiled in the Southern District of Ohio. As I understand it, it's still currently pending in the Southern District of Ohio, and it will most likely wind its way back to the Sixth Circuit, which is why I still call it the Sixth Circuit litigation. But there hasn't actually been any activity on that in a while, but that's one case to follow very, very closely. The other is Brody Mining. And there's actually two Brody Mining cases. The one that's before the commission is the one that I've listed. This was the challenge to Brody Mining LLC, which received a pattern of violation notice and challenged that notice and the application of the rule to the mine. The case was heard by Judge Moran, who dismissed the pattern of violation notice for various reasons related to MSHA's failure to define what a pattern is or why it found the allegation that this particular mine was subject to the pattern. MSHA appealed that dismissal to the commission. It is currently pending before the commission. Oral argument was held, but a written decision has not been issued. When that written decision is issued, we may see some illumination of some of the key terms of pattern. But there's another Brody Mining case that's similar to the Sixth Circuit case, which is the challenge to the rule. This is a more broad challenge to the actual validity of the rule, and that's currently pending before the D.C. Circuit Court of Appeals. So we really have two circuit court cases currently pending, as well as a commission case. So lots of appellate litigation out there that is currently pending. I would expect to see some movement in all of these cases in the next year, and we can certainly revisit what all of this means once some of those cases have come to decision. Perhaps we'll have some resolution, or perhaps we will not. Perhaps we'll have some more uncertainty. But anyway, in looking at the litigation, not to paint with too broad a brush, but the issues are pretty similar. The issues are pretty similar across both of the Brody Mining cases and the Sixth Circuit litigation. Industry has taken the position that the screening criteria, all those criteria that we put on the slides earlier that you follow, I'm sure, on the website, that this is really the criteria. This is how MSHA makes its decisions as to who's going to go forward on the pattern and who's not. And that as a result, it's a binding norm, and it is subject to notice and comment rulemaking, and there was no notice and comment rulemaking. And as a result, the industry groups have claimed that it is invalid, that the rule is invalid, because this is what it's relying on. MSHA has taken a different position. It's saying that those screening criteria, you have criteria A and criteria B, that's not what it uses to make the determination of who's on the pattern. That's just how it screens people. But once it makes the decision that a mine has passed the screening test, that those criteria essentially are irrelevant. And so as a result, MSHA is claiming it's not required, that there's not a requirement of notice and comment rulemaking. It's a non-binding statement of agency policy. Interestingly, in Brody's challenge to the validity of the rule, which, as I said, is before the D.C. Circuit currently, the dissenting commissioner in that case, Commissioner Alton, essentially said, I'm not buying any distinction between screening criteria and final criteria. These are the only criteria MSHA has given. And remember when we started this discussion, we said MSHA, part of the rule is MSHA is to set forth written criteria. Commissioner Alton said, these are the only criteria MSHA's given. So I'm not going to place a lot of value on them calling it screening criteria. As I see it, these are the criteria. As a result, Commissioner Alton found it was required to go through notice and comment rulemaking. His was the dissenting voice, but again, that case is before the D.C. Circuit, so the final chapter in that book is not yet written. Next point, and the one that really has probably gotten the most amount of angst for those in industry, is the due process issue. Prior versions of the POV rule required, at least in part, that POV determinations be made based on final orders, meaning that you're issued a citation, you exercise your right to contest it, you contest it, and it's not a final order until a judge makes a decision and you've exercised all your appeal rights. That's due process. The new rule says, no, a POV determination can be made based on citations as they're issued before they become final. Industry has said this is a violation of due process. We have not yet we have a statutory right to contest, and we're being put on POV before we're able to exercise that right. MSHA is arguing that the Act allows for the use of non-final citations or orders. That is an issue. That's a very, very key issue. I'm sure most of us are familiar with that issue. That is involved in all of the litigation that is involved with pattern of violations. Again, those cases are all still pending, but this is a key point that has yet to be resolved. And finally, related to that point, is there a pre-deprivation process? So if we're going to use non-final citations and orders, what is the process that a mine is entitled to before they're put on POV? Are they entitled to any? Obviously, the industry litigants take the position that yes, if we are subjected to use non-final citations or orders, then constitutional due process requires that we're entitled to some sort of process. MSHA has taken the position that the rules in the current commission structure and procedures provide adequate process. And again, that is up in the air currently. So very, very important issues that will define the future of pattern of violations are pending before various appellate bodies right now. So when I say where are we with POV, a lot of uncertainty. Some additional questions that have come up in the litigation. What is a pattern? MSHA has been asked to define pattern in several of the litigations, and they've come up with varying definitions, one of which was based on the definition of pattern in Black's Law Dictionary. Now they've backed off that somewhat, but that's the type of definition we've seen from MSHA. In my opinion, that's really not answering the question, because basic administrative law is that MSHA was required to promulgate rules to implement the pattern provision of the Act. That presumes that they're going to undertake some type of critical analysis to do so. By simply referring to Black's Law Dictionary certainly doesn't meet that test, in my opinion. So what is a pattern? We have not identified that yet. Very basic question. Once a POV notice is issued, what can you contest? Again, going back to your process, whole issue of process. Can you contest the notice? You're told you're on a POV. Can you contest the citations listed in the notice that MSHA is saying make up the pattern? What about those screening criteria? That's how they identified you in the first place. Can you go back and contest those? Say, hey, look, we should have never even been screened because those violations were invalid. All open questions. And then again, what is the effect of the screening criteria? What's interesting is MSHA gives you this very useful tool to monitor your POV status on the internet, and then they turn around in the litigation and say that that tool is irrelevant. Those criteria are irrelevant once you've been identified. Going forward, again, we'll talk about some practical tips in this world of great uncertainty that we live in. First is, again, it's obvious that the screening criteria, while we don't know the exact role that they do play a role. They're not totally irrelevant, at least before you've been identified. That's what MSHA monitors to determine if you're even going to be considered. I commend every mine to do the same. Everybody should check their status on a very, very regular basis, and frankly, I think most mines are doing that. Take steps to reduce number of S&S violations. This is maybe an overly obvious one because that's the basis for any POV, for meeting the POV screening criteria. But in addition to simply taking steps to avoid getting S&S violations, take steps to actually challenge erroneous S&S violations. We've all heard about the backlog, that there had been a backlog of contested cases. The backlog has effectively been reduced, and that's a good thing for all of us. One of the reasons it's a good thing for us is we're starting to see citations come through citations that have been contested come through the litigation process much earlier than we used to before. I'm seeing citations that have been contested now getting assigned to judges, getting assigned to solicitors that are only 6 months old. That was unheard of a couple of years ago. Well, the result of that is you're actually able to get some resolution to some of these S&S citations that are still within the POV window. We can get S&S citations reduced that are still within the 12-month POV window that they're looking at. So if MSHA is really looking at citations that are issued, we can and not waiting for them to be final orders, we can actually get them changed while it's still within that window. A note on S&S violations outside that window. I think they're still relevant. That they are still relevant, and it is useful to get those reduced as well to the degree that you can, because all these issues are still uncertain. If the screening criteria, in fact, is relevant to a POV determination, then it behooves a mine to try to get as many S&S violations reduced to non-S&S, even back before the 12-month window, because that may have been used in the screening criteria. And that issue is still open for what it means. We talked a lot about the Compliance Assistance Program. I'll just say one more quick word about it, and that is, again, if it's something, if there's a concern that a mine is getting close to meeting the POV screening criteria, it behooves the mine to start discussing the Compliance Assistance Program option very, very early on. It's the type of thing you want to engage, upper management on, legal counsel on, that type of thing, because you want to really explore that option before it becomes too late, and you want to consider, if it is a road you choose to take, what it's going to mean for your mine. So be very, very careful with that option, whether or not you wish to exercise it. if a mine appears to be close to meeting the screening criteria, there is a provision in the Act that allows for an expedited hearing. MSHA has said that meets all the requirements of pre-deprivation process. Industry has opposed that, but even if MSHA is correct, that's still an option. So SNS, expedited hearing on SNS citation is an option, frankly, under any circumstances that if a mine is close to meeting the pattern of violations screening criteria and can be exercised. And finally, follow the legal developments. With 3 appellate cases kicking around out there, we could have this same presentation a year from now and it would look very, very different. We'll certainly do our best as a law firm to keep you apprised on all the developments as they come to pass, but keep up with this stuff because it's a changing world and could change very dramatically in a short period of time. So with that said, that concludes our presentation. We have a few minutes. We concluded a few minutes early. If there are any questions on either POV or flagrant, be happy to take them. If you think of any questions later, my email address is on there. Feel free to email me or give me a call.
Great, thank you, Arthur. We had had one question pop up, but I believe that you just addressed it, indicating that it was really important to look at the unique situation for each company before implementing a corrective action plan.
Okay.
Specifically, they had asked, what are your thoughts about a mine operator volunteering to develop and propose a corrective action plan to MSHA on its own without any prompting from the agency? Do you have anything to add?
Yeah, actually, let me just say one more thing, because it really is a very, very serious thing to consider, and I think the questioner really got at the heart of the issue, because you are volunteering to put more burden on yourself. That's something that, mines are not going to do willingly unless you have a very good reason. The very good reason would be, of course, that you're getting close to a pattern. So it's something you must consider very, very closely. Now, I have heard in one instance of MSHA actually approaching a mine and saying that, and suggesting that they consider a corrective action program, and in that case, the mine wasn't even really all that close to a pattern of violations. So that's something, I would not suggest doing simply because MSHA suggested it. I think you need to look very, very closely at your circumstances before you go down that road.
Great, well, thank you. We're coming up on our 1-hour time limit. Again, a copy of this presentation will be emailed to you, to our attendees and to non-attendees. If you have any specific questions, if you want to reach out to either Arthur or any of your contacts at Jackson Kelly, we would encourage you to do so, and we appreciate your time. Thank you.